Now that you've heard about the origination of a Title IX complaint, I'm going to walk through how these complaints are resolved. One potential option for resolving Title IX complaints is the informal resolution process. True to its name, this informal resolution process lacks the convention of a hearing and is more akin to a non-binding mediation, where a neutral party is used to facilitate an outcome agreeable to both the complainant and the respondent. Under the 2020 regulations, schools can only offer the option of an informal resolution after a formal complaint has been filed. Notice of and consent to the informal resolution process must be in writing, and students cannot be forced to participate in the informal process. Additionally, the informal resolution process cannot be utilized when the allegations involve a university employee sexually harassing a student. Under the proposed regulations, schools can bar the use of the informal resolution process if they determine that the alleged conduct would present a future risk of harm to others. In such a case, schools can decline to offer the informal resolution process even if all parties wish to utilize it. As a result, both complainants and respondents will potentially have fewer options for resolving Title IX matters if the proposed regulations are adopted as written. This is unfortunate. In our practice, we've had success using the informal resolution process to resolve cases that involve conduct such as stalking, which may fall under the umbrella of conduct that schools determine to present a future risk of harm to others. As currently written, the proposed regulations could require students to go through a formal process even if it could have been resolved without the stress that accompanies that formal process. If a formal process is required, then the school needs to deal with the appropriate standard of proof. Under the 2020 regulations, the same standard of proof must be used for all Title IX disciplinary proceedings, regardless of whether they involve students or faculty. Schools are able to choose either the preponderance of the evidence standard or the clear and convincing evidence standard. Under the preponderance of the evidence standard, the burden of proof is met when the party with the burden convinces the fact finder that there is a greater than 50% chance that the claim is true. Under the more exacting clear and convincing evidence standard, the party with the burden must present evidence that leaves a firm belief or conviction that it is highly probable that the factual contentions of the claim are true. In Title IX matters, the burden of proof is always on the institution to prove that that a violation occurred. And that remains the case under the 2020 regulations and the proposed rules. However, under the proposed rules, the default standard of proof is preponderance of the evidence. Schools can only use the clear and convincing evidence standard if it is used for all comparable proceedings, such as other discrimination complaints. Additionally, under the proposed rules, schools are no longer required to use the same standard of proof for student cases as they are with faculty cases. Due to the more arcane nature of the clear and convincing evidence standard, it is very likely that schools will overwhelmingly, and perhaps exclusively, rely on the preponderance of the evidence standard when determining Title IX matters.